Any mention?
Item number 43, here the petitioner has resigned from service. So the writ fact has become infructuous.
Government is Mokon.
Yes, Your Lordship.
The party submit that the writ petition has been rather infructuous as the writ petitioner since resigned from service. According matter stands disposed of and being infructuous.
All right.
Yes.
Please, Lordship, I beg to mention the item number 38, 39 is connected matter, Lordship. This is regarding the civil revision. Actually, I have some difficulties, personal difficulties.
Why difficulties is this is the oldest, I think, matter maybe in my court.
Yes, Lordship, actually I am ready, but only thing I have some appointment with after, I may not get time, Lordship, only on that.
I am only in 39.
38, 39 are connected. Yes, after 2 weeks, and the request of the counsel for the
about a respondent, Lordship.
for the respondents. Yes.
Lordship, similar prayer for item number 46. Here I am the petitioner, Lordship. I have informed to the
46.
yes, Lordship.
Yes.
After 1 week, Lordship.
2 weeks. Yes.
Much less, Lordship.
Yes.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 47, Your Lordship. I pray for 2 weeks' time, Your Lordship.
For the petitioner, Lordship. No objection, Lordship.
Why 2 weeks time?
We need some more time to prepare, Your Lordship.
2 weeks time request of the counsel of the respondents. Yes,
Highly
sir.
obliged, Your Lordship.
Highly obliged.
Wait, please, Your Lordship. Lordship, I beg to mention item number 40. My Lord, Mr. B. Pathak has some personal difficulties. Maybe the matter may be come after 3 weeks, my Lord.
3 weeks request difficulty of the counsel of the petitioner. No objection.
Your Lordship, I beg to mention item 37, Your Lordship. Contempt matter. Your Lordship, this matter may kindly be taken up after 2 weeks.
Lordship, I am entering appearance on behalf of the petitioner, Lordship.
And Samir Chandra. Very good.
Lordship, I have a limited submission, Lordship. Here, Lordship, I filed one petition for implement of new parties, and by order dated 5/9/2022, Your Lordship was pleased to direct the registry to make the necessary changes. But Lordship, till date, the changes has not been made.
Are you sure about that?
Yes, Your Lordship, because on last, the order also is saying that, Lordship, Mr. Rajiv Goba, even in the cost list also it is showing Rajiv Goba.
No, but he's been added subsequently, I think. Say 37.
In the order sheet also it is showing.
It's already there.
But Lordship, the order sheet and as well as the cost list also, Lordship, it is showing.
It's there. It's there in the cost title of the petition. What more do you need?
Alright, Lordship. But in the cost list, Lordship, it is showing.
Cost list is cost list, but what matters is the cost title in the petition.
And in
Correct?
the order sheet also, Lordship. Order sheet also.
Order sheet also what?
Rajiv.
Doesn't matter. You have to be struck off. It's still remaining. This is but this is it connected to some other matter? No, still there. Rajiv Goba, number 2, Lieutenant General Sukhdeep Sangwan is retired. Also Gobind Singh, Deputy Commandant. Then 4 is Ajay Kumar Bhalla, and 7 is Pradeep Chandra Nair. He's the new DG.
And
The request of the Ms. S. Ramthau, and on a joint request of Mr. S. B. Tapusis entered appearance on behalf of who's been newly engaged behalf of the petitioner and Ms. S. Ramthau to respond to this matter of 3 weeks. Yes.
Lordship, one more small submission, Lordship.
No, enough. What's more submission?
Lordship, on February.
Enough. Unless you do the hearing today. You ready to do it today?
No, Lordship.
Then take out the file. We'll do it right now.
They are saying,
Upgrade
Lordship, they will be produce some.
No. Don't make this kind of small submissions in mentioned time.
Your Lordship, I also beg to mention item 42, Your Lordship. This matter can kindly be taken after a week's, Your Lordship. 42.
Yes, who's appearing for the side?
That other one is.
Yes.
Your case, my lord, promotional case, my lord,
1 week.
Education Department, pending for 2020 for no reason, my lord. There are a series of cases somewhere between. Only 2 cases are filing. One is coming today, tomorrow is another case, my lord.
After 1 week, at the request of the counsel for the petitioner.
Much.
This is item number 48 and 49, Your Lordship. I'm appearing correspondent number 4 for court.
Number 4?
After 2 weeks, Your Lordship.
But this one was about to be disposed of, correct?
Yes, Your Lordship.
No.
Hearing.
40 and 49?
Yes, Your Lordship. Only 2 weeks.
Why, Mr. Karia?
I'll prepare, Lordship.
For 2 weeks. 49 years.
Obliged.
That's it, yes?
Your Lordship, I beg to mention item number 2 and 14.
Number?
2 and 14.
2 of the orders?
Yeah.
Don't mention orders. You don't. How many times I will
Counsel for
tell?
the petitioner is only there.
Doesn't matter how many times I have told the counsel, junior counsel, please don't mention order matters. Only hearing matters you can mention, yes.
That's only.
What is this? Be here when the matter is called out.
May I please, Your Lordship, item number 36.
Oh, he's still there, 36. Where's Mr. Qureshi?
He's having some personal difficulties.
Personal difficulties in appearing in this court or his real personal difficulties?
He's having personal difficulties.
No objection. 2 weeks to personal difficulty of the counsel for the petitioner. Yes.
Obliged, Your Lordship.
Supplementary list, item number 1.
The petitioner before Your Lordship, they are the member of the society, Lordship, and they are aggrieved by the impugned approval order issued by the Assistant Registrar of Society, Lordship, granting approval to the resolution taken in the special general meeting, Lordship.
Where's the impugned order?
They'll be at page 87, Lordship, and extra 7.
It's more than 1 year, Mr.
Yes, Your Lordship. We have been pursued a matter with the registrar, Your Lordship, where Assistant Registrar inquiry has been done, Your Lordship, but inquiry went against us, Your Lordship.
Inquiry is held subsequent to this order?
Yes, Your Lordship.
So you aggrieved with there's no form of appeal against such orders by registrar of societies?
For the registrar only, Your Lordship.
Registrar conducted the inquiry?
Yes, Your Lordship.
Where is that inquiry?
Registrar instructed to conduct the inquiry, Your Lordship.
Now, what happened in inquiry? What did they? What was the finding?
The only issue in this case, Your Lordship, because in the purported special meeting, the signatories are 266 signatories are there.
There
are 266 signatories in the special meeting, Your Lordship. Our stand is that out of 266 signatories, only 5 are the genuine members, Your Lordship. The rest, they are not the member of Your Lordship.
You mean they're not members of the society?
No, not at all, Your Lordship.
And how will the court ascertain that?
Because
sitting in the jurisdiction, whether those members are the correct members on the materials produced, we can ascertain that.
Yes, we can ascertain, Your Lordship. We can ascertain.
So you say that, but why have you come so late?
Because we have been pursuing with the rest.
So what's the situation in society now? It's been taken away from you.
It's taken away, Your Lordship.
Then what are you doing? Nothing.
Now we are the members, Your Lordship. We are not allowed to participate in the activities of the society also, Your Lordship. In spite of.
Now who's the petitioner?
The petitioner, they are members of society, Your Lordship.
Is this a member?
They are the members, Your Lordship.
Okay. Yes, sir.
Your Lordship, I'm appearing on behalf of the state respondent, Your Lordship. This, I need some instructions, Your Lordship, because...
Also, still, why have they come after 1 year? And if you feel it's arbitrary, it should have come anyway. Heard Mr. Ahmad issue notice, returnable in 3 weeks. MST Yangi Leonard AAG with so-and-so is present and accepts notice will be half of response 1 to 5. 1 to 5. What do you mean by purported chairman? What do you mean purported managing committee? That can you put down the course title?
Because they have been appointed based on that.
No, whatever it is, are they functions of the chairman and
at the moment they are chairman and
how could they purported?
Maybe allowed to rectify.
You delete that part.
Yes, Lord.
So notice accepted so and so. Ms. Armujao, with regard to other respondents, please be allowed to delete the offending portion wherein the word purported has been shown as against respondents 7 and 8. After said correction, the cause title, petitioner will take steps by said AD on the remaining the other response within 6, 7, 8 within 3 days. Just up to 3 weeks.
Main list item number 1.
Please proceed. My lord, as per the last order, we file an affidavit, bring into record the application that they have filed, the private respondent has filed before the CEM, my lord. And on the basis of that application, delay was condoned. But his order doesn't speak so. His order speak otherwise, my lord. But the cause title of the application was for condonation of delay. My lord, there is an affidavit I have filed.
This file?
Yes.
Actually,
Affidavit dated 19 May.
It should have been separate application. That is what it means.
Where's the
appeal and also continuation of delay? They have filed in only one petition.
My lord, may kindly come to the affidavit that I filed on 19th May 2023, page 8, my lord.
Yes.
Annexure 2, page 8. An application by the applicant seeking condonation for the delay and for. He has added both, my lord. So we cannot say that they have not filed, and we cannot accept also that they have filed. We are in that position.
They should have been separate. But my submission, Your Lordship, this is not only the case of a delay, Your Lordship. See the conduct of the.
No, we're not there yet. The only thing that the court wanted to see is whether there was a separate application for condonation before the chief executive member to consider first condoning the delay, and then if he condoned the delay, then the appeal would be taken back on board for adjudication. That's the thing, right?
Yes. But here it is arbitrary fact, no separate application.
But we can't bind them with the strict rules of procedure also once.
And so for the mistake of the lawyer should have understood. But if lawyer has not filed, how the client can suffer, my lord, for that?
Yes, where is that?
Just submission, Lordship, small submission.
Yes.
Your Lordship, of course, only to see whether separate condonation has been filed or not. That is true. But here, Lordship, we go by the record. This private respondent, they happened willfully.
That will examine. I will just take down an affidavit bringing on record the Mrs. appeal filed by the respondent number.
4 and 5.
You are 4 and 5. You are the one who filed. Okay. 4 and 5 has been brought on record by way of affidavit stop. A perusal of the said application shows that the application was the application sought for condonation of delay and the same time for recall of the order dated 12/2010 for hearing the appeal. Stop. Next paragraph. Though it has been contended by the counsel for the petitioner that a separate application should have been preferred as directed as per procedure. Stop. Mr. S. Day submits that due to the latches of the lawyer, the respondents being literate should not be made to suffer. Accordingly, it's for admission today.
Yeah, it is for admission.
The matter is admitted for consideration. Yes, you file affidavit. Petition to file affidavit within
3 weeks.
Within 3 weeks.
Yes.
Or not affidavit. They have to file affidavit. Sorry,
we have to file that.
Sorry, the respondent file affidavit within 3 weeks.
Must place Lordship.
Item number 2.
Yes, where's that lady? Where's that counsel sought time? Where's the rejoinder affidavit? Where's the rejoinder affidavit? Has that been filed? How many times, how many occasions, how many times have you taken time? Yes.
Lordship, I think just once.
Okay, further 2 weeks time granted to the petitioner to file a joint affidavit. Yes. See, don't take time for these things. They are not the final matters. So their orders are being passed. You don't adjourn the order.
Lordship.
Doesn't matter.
Item number 3.
These are for arguments.
This lawsuit. This they have filed the affidavit lawsuit. I just need to get a clear instruction from the client whether they said they have paid some amount till November 2021. But when I talked to the petitioner, they said it's not correct. It's because they have adjusted even their own salary. They have withdrawn and they have taken back. To that effect,
I don't understand anything he's saying.
Because they're claiming that they have paid the full salary till 2000.
Whose salary, from whom, who's being paid, how they've been paid? You expect this court to be as bright as you, Mr. Sangman? No. We're very slow. What is the matter about Bagmara Municipal Board?
Bagmara Municipal for non-payment of salary lawsuit.
Yes.
I'm so sorry. Fake of the case. They have not paid the salary, so we have come before this court. At the time of filing, they have filed the affidavit saying that they have cleared the amount, the salary since till November 2022.
No, March 2022.
March 22.
Yes. So the petitioner, they are disputing that. So I just need to file some small affidavit because it has to be on record.
Now, if there is
on what basis they are disputing?
If there is a dispute, my lord, that salary, I say that I have paid till March 2022. And my friend is saying that no, we have not received till March 22. It's a disputed question of facts, my lord.
No. You've annexed these things also.
We have enclosed, my lord.
And what do you say to this, Mr. Sangma? See the last affidavit filed by the respondents.
And the allegation of the petitioner was that, my lord, the fund we have received from the state government has been misappropriated. And we have given the total calculation. How much we have received and how much we have disbursed, my lord. And the RTI that he has received from a third person, he has not filed any RTI, my lord. It is the third person who has filed an RTI.
But it does not bar from bringing on record because this is just an information.
Now, any person, as my friend is saying, my lord, any person can file and any person can file.
By the petitioner, because this is just an information. Just an information. You may not have any connection with the petitioner, but this is just to bring on record. Whatever may be, even if they are saying that they have cleared, but till there are some months from 2020.
See, we're not going to go there. You look at the affidavit. Have you seen the affidavit filed by them? They have annexed a chart also showing the names and till how long they've been paid. Have you seen it?
But still.
No, I'm not. But have you seen the chart?
I've seen it also.
Then what do you have to say on this this annexure number 4 series? 2021, then after that it's 2722 March. If you have anything to dispute, you come with concrete facts.
I will just file a small.
I will close it.
Even the lordship, they have paid only till March 2022.
Now you're admitting. Just now you said no.
Till March only, my lord. Now it's already 2023.
Right.
March 2002
this petition
also
was
they
for
have
a
not
particular
cleared.
period of time. He was agreed with a particular period of time, and we have shown that we have prayed, my lord.
We'll show one thing. Just see his prayer. They have to be paid the salaries, whatever it is.
They have to clear. Now we are already 2023.
Now page 7 is the prayer, my lord.
7A.
The matter was filed in 2021, October 2021, my lord.
How come the two prayers? 7A?
Yes, amended.
Benefit with effect from March.
One prayer from September 2016.
There was correction, my lord. To that effect, I have corrected. Lordship has allowed. There was order also. There was a defect in the prayer, but later on it was corrected, lordship. So the correct one is from March. From March 2021.
What reason have you shown, Mr. Dev, day regarding the non-payment of up to date.
So I could not follow, my lord.
What was the reason you showed me affidavit saying that why you couldn't pay the amount?
It is the fund, my lord. Because we are totally dependent on the state government, my lord.
Who is the paid for the state? I met them party. The funds were paid.
We release the fund, whatever fund the state can help.
Till?
Assistance money. I want to report, 2023 funds have also been reported released by the financial group.
Where's the document?
Let them file, my lord.
You file affidavit. Take down. Mr. S. Dale, the counsel for the respondents number 3 and 4.
Yes, ma'am.
My view affidavit has stated that has shown that the salaries of the writ petitioner have been paid till March 2022. Stop. Mr. P.T. Sangma, local counsel petitioner, prays him to obtain instructions as to this, as to whether the petitions have been paid. Stop. He when paid. Stop. Next paragraph. M.S. R. Colney, local counsel for the state respondents number 1 and 2, however, submits that the excuse given by the respondents 3 and 4 is factually incorrect, as much as funds have been released by state government to the respondents 3 and 4 for payment of salary. Stop. Leonard G is directed to bring the same on record with affidavit. Yes. Well, how is that possible? Just after 2 weeks.
Lordship. Item number 4.
Lordship, I've already filed the rejoinder. The exchange of pleadings completed, let it come for hearing.
Query submit appeals to complete this matter for hearing in the usual course, and so on. So
5.
you file your objection?
Yes.
Where Mr. Bora?
Yes, I was stationed.
How many days the delay? 1,000 and
53.
1,053.
1,083 days.
When is he coming back?
Tomorrow.
Tomorrow. Tomorrow is coming. When did you file your objection, Mr. Nomri?
No, this was filed in April.
Adjournment sought on behalf of the Bora for State North Station. This is a matter after 2 weeks. Yes.
Item number 6.
Please, Lordship. Lordship, I'm praying for a further week's time. It's been sent for signatures, my lord, to Assam.
How many times you taken?
Taken, my lord, 3 times or so.
This is the 4th time.
1 week, my lord, because this was concerning the death of the petitioner's son at Nepal, so the person is at Assam.
Yes, this matter for hearing after 3 weeks. Petitioner will reply to join in the meanwhile.
Right, Lordship. 7.
Lord, I'm praying this matter may pass over for the day, my lord. It's MTC.
What is the situation?
Its BP proceedings have resumed and settlement talks have failed.
So what do you want to do?
There are some developments, my lord. Can you fix it tomorrow, my lord?
Tomorrow is
21st.
the longest day in the year. Yeah, okay. MS Adatta, these are the matter. We pass over the day. Okay. This is matter. We won't list it tomorrow. We list it on. We'll list on Friday. It's a matter on Friday.
8.
Where's that counsel appeared, Mr. Bora? That didn't have taken steps till now. None appears for the petition. If not justice, this is matter after 1 week.
9.
Yes.
It's just given 2 weeks and average if Parvas to me, I'm given 2 weeks and fine.
Mr. Jabran pays for the further 2 weeks time to file affidavit just thereafter and so on.
10.
Please, Lordship. Lordship, I'm praying behalf on respondent number 4. I'm praying further 2 weeks time to file affidavit.
What about 1, 2, 3?
We've already received affidavit from 1 to 3.
You already received the affidavit?
Yes, sir.
1, 2, 3 is already filed?
Yes, sir. 1 to 3.
Yes, MS Pasa pays for the further 2 weeks time to file affidavit just thereafter and so on.
11.
Yes. Where's Mr. Wajri?
He's out of station, Your Lordship.
This matters on the. You've seen the last order?
I'm sorry, I apologize. I have not checked, Your Lordship.
Because the state has raised objections that there's no cause of action in the matter. When is it available?
By next week, Your Lordship.
Yes, accommodation is sought on behalf of Mr. D.K. Wajri. Our counsel is not available in the court today. Only this is matter after 2 weeks. You tell him it's on the maintainability.
12.
They have filed the affidavit. They sent me a copy yesterday, my lord. I'll just file a short rejoinder, Your Lordship.
What rejoinder? What did we see in the affidavit?
They are saying, my lord, they have shifted. They have admitted that.
Another part is that they have offered the same land which the private respondent has offered.
My lord, I'll explain. That's why I filed a short.
No. Only thing that this court concerned whether any third party interest has been created. Because that was last time Mr. Sen, he said you don't have any concrete information as to who's running the other toll revenue station, right? That once they come with affidavit, then you would be sure as to whether it is a third party is involved now in like this revenue station for which.
My lord, I'll file. That's why, my lord, I'll bring all these things to Your Lordship notice. Just give me a week's time, Your Lordship. Let it come up next week. Before that, I'll file. I have started preparing already.
Otherwise, till when's the lease? The original lease it was for 3 years.
3 years.
3 years.
From the date of commencement, date of agreement.
That was last year.
Yeah. Yes. The way this thing has been done, my lord.
The only thing is that whether the cause of action has been
no, my lord.
Cause
of action, my lord. I don't know, Your Lordship. Recently, Supreme Court has passed an order. Now, my lord, normally what Your Lordship normally say, tender and contractual matter, ream of contract, civil court and all. There they have distinguished and they have coined a new phrase, tender jurisdiction of the High Court. So it's very limited.
Right. Then exactly that's what. Then whether third party interests have been created, whether disputed facts are there with regard to the shifting of the railway station, whether sitting in the jurisdiction, whether we can is there any scope for us to
the narrow scope. Whether this case come within that narrow scope, I'll try to satisfy my lord.
No, but what has happened these third party. There's a third party running it now. You say.
Lordship, that has been run by the district council itself through an agent, Your Lordship.
Same thing. It's the same thing.
Not by way of lease or anything.
So, it comes back to the same thing, Your Lordship. That's what I'll satisfy Your Lordship. I'll satisfy Your Lordship, my lord. Whether it comes within the narrow scope. There was a concluded contract. Once there is a concluded contract, my lord, it cannot be. So long I am willing to perform my part. Now they are saying that I have offered the same land.
There's another aspect to the matter in the sense that conditions as given as per your tender, they've changed also because you offered the land which was to the second highest bidder whose bid was cancelled by this court.
But there are two things. Private negotiations. Now, private negotiation after the tender is permissible. If there is a private negotiation, then other tenderer also will have to be given a scope. Those things will. So that I'll satisfy Your Lordship, my lord. That is not
complicated, Mrs. Sen.
No, I'll try to satisfy my lord. I'll try. Lordship, give me a week time.
An affidavit has been filed on behalf of the respondent's number. Yeah. On behalf of the respondent staff. Mr. SN, the council petitioner, prays for is allowed 1 week's time to file rejoinder to the same list thereafter. And so.
The interim order to continue.
Not one interim order, they are
not to lease out. You do not know, my lord, they will lease out. Since it is there, it will continue.
Interim order of any shall continue until further orders.
Yes.
13.
This is the.
Your Lordship will seek 2 weeks time for filing rejoinder.
You are Mr.
For my senior counsel S. Pandey.
No, your name.
S. Majha.
Yes, Mr. S. Majha, Vice Mr. S. Pandey, please consult out for 2 weeks time to file a rejoinder affidavit. List thereafter.
All right.
14.
Your Lordship, in this matter, I'm praying for further 3 weeks' time, Your Lordship, to file the affidavit.
MS Amrutha, please follow up for 3 weeks time to file affidavit. Yes.
15.
May please, Your Lordship. I have come up with an application for vacation and modification of the interim order passed by this Honorable Court. And
What matter is this?
The writ petition was
Samrat
filed-
Inder Singh.
Yes, yes.
What's the matter about?
Well, a tender process was initiated and even a technical
One
bid...
second. Okay. Tenders for what commodity?
my lord, supply of ration and fresh...
You're for the petitioner?
Yes, Your
Have you received a copy of this?
I have served the copy.
Have you received a copy of the application for vacation? Of the interim order? Interim order dated when?
it was on 12th of May.
When
No,
was
your
it?
copy has not served to me.
You serve a copy, they have the
We
right to
already
reply.
served copy. Huh?
He is the counsel who is dealing with this. I am also, he is the not from here, he is from Silchar.
See, don't argue among yourselves, you tell the court what is
No,
wrong.
Your Honor, he is asking who is Chaudhary.
The counsel Mr. S. Chaudhary has been served with the copy.
Who is Mr. S. Chaudhary?
S. Chaudhary, he is the senior counsel for this case. He is from Silchar.
We'll give you 1 week's time to reply, that's all.
But
So we
copy
have
has not
to-
served to me, Your Honor. And I have talked today morning. There are nothing was there that they have served copy.
Who was this who received? Who's K. Guru?
That's one of my colleagues.
Okay. You serve to. Why do you serve to the correspondent?
Served it on Junior Malot because as Chaudhary Malot we couldn't find him in spite of.
Then you serve a copy today. Miss case number 90/2023 in the WBC number 104/2023. This application has been filed for vacation, alteration, modification of the order dated when, Ms. Goyal?
12/5.
20?
12/5.
12/5/2023. Stop. 12/5/2023.
My lord.
Pass in the WBC number 104/2023. Stop. Next paragraph. MS M.K. Shah submits that he is led by Mr. S. Chaudhary in the matter, and he is not in receipt of a copy of the said application. Stop. MS B. Goyal on behalf of the respondent applicant number.
The applicant, my lord. So applicant and respondent number 3 in the writ petition.
Yes, applicant stroke respondent number 3 submits a copy has been served. So, however, she directed to file a
Can it be taken up tomorrow, my lord?
to serve a copy
just now?
on the
No, Your Honor, it's not possible. He have to
counsel
come.
please consult the petitioner within the course of the day. A reply thereof to be filed within 1 week. List the matter on Monday. Yeah.
I'm grateful.
16.
My lord, can
Don't you have problems on Monday?
Tuesday, my lord,
Tuesday, okay.
I'm grateful, my lord.
Yes, Mr. Sen.
These matters are against the corporation relating to release of retirement benefits. May
4
just pray
months.
for 5 months minutes.
5 months, no?
Similar order for 16, 17 and 18 minutes. 3 items.
16, 17. This is item number 15.
This is
16, 17, 18. 5 months.
Highly pledged.
19.
Please, Your Lordships.
Yes, Mr. Deb.
This was the matter, my lord, where
This MSP versus Haji, I notice, is on leave.
leave, my lord. I'm praying if you can come up tomorrow, my lord, because the urgency was, my lord, that the in persons to the recovery proceedings, the bank account of the school has been frozen. So it is, my lord, in fact, they are also not in a position to recover. We are also not in a position to operate the bank account of the school, my lord.
What is the penalty or damages due?
The penalty was, my lord,
14B.
14B and 7Q, my lord. But the impugn order itself had some, my lord, apparent typographical or calculation errors with regards to the period and the amounts. So, my lord, the coordinate bench, my lord, was pleased to allow the parties to sit down and resolve the dispute, if any. But my lord, the understanding was that the freezing of the bank account will be lifted, but that has not been done. So therefore the urgency, my lord, because the school is otherwise.
Well, what do you do? There's no counsel.
It may come up tomorrow, my lord. She's on leave till today.
Today is 20th.
Lordship.
Yes, as the counsel for the respondent on leave, this is matter. What? For the 1 2 3 only. Why was no notice issued? Why you not filed? Taken steps on number 4?
No, my lord. Actually, what happened, my lord, was that what happened was, my lord, that in the coordinate bench an interim order was passed, but that interim order was unfortunately not reflected in the certified copy. Thereafter, my lord, we had spoken to his lordship for the clarification. So, but before that, my lord, the matter was transferred to this honorable bench.
No, not doesn't transfer. Now, if you are seeking to defreeze an account,
lordship,
at least the bank on where the account is should be made, should be aware of it. Why haven't you taken steps?
I think, my lord, we had taken steps yesterday because of the issue in the. No, that because there was some because we thought, my lord, that probably the order will be corrected, which is why we did not take steps.
You made an application for correction order. You made it orally before the judge and chamber.
Yes, my lord. Because
is that possible?
Interim order which was passed in the open court was not reflected. It came to the notice of the judge, my lord, and he said that it will be taken up on the next date. But on the next date, my lord, before it could be taken up, on that day it's also the.
Send it back there.
Why?
This note indicates that steps have not been taken to respond number 4, pursuant to order dated AC 2023. Stop, Mr. SDEP has made submissions that certain orders have been passed, which is correction by the coordinate bench that have passed the order accordingly. This is a matter before the other bench.
20.
May I please, Your Lordship? My lord, here we are before this honourable court, challenging the order of the Lokayukt, my lord.
Yes, Mr.
Please, Your Lordship. Lordship, I'm entering appearance today on behalf of 1, 2, and 3. Challenge in this particular writ petition, my lord, is against one particular order passed by Lokayukta. As per that order, charge sheet has been ordered to be filed against the petitioners, my lord. Now, the stand of the petitioners is that, according to them, Section 21 of the Act, Lokayukta Act, prescribes a certain specific procedure, which, according to them, has not been followed. My response is very simple. Section 21 has absolutely no role to play. For this honorable court to better appreciate the submission, maybe a small affidavit is required, a short affidavit from my side, about a week or 10 days time may be given.
Lordship, actually, I'm appearing for private respondent number 4.
You're the complainant.
Lordship, in fact, this whole writ petition become rendered infectious because the honorable that Lokayukta passed an order on 18/5/2023, and the special judge of Tura has taken cognizance this matter on 23/05/2023, and this order was not before this court. They have not challenged your lordship, and then your lordship.
Mr. Dev will be well aware.
They have filed a
No, we are not aware, my lord.
They have filed a writ petition after the author of this order. They have filed a writ petition on 31st May 2023. And then there is order, your lordship, from the division bench also. There is another person who have
My lord, there is
Both
a stay
the court
from both the court, my lord. Division bench also has stayed, and also the
There is no
learned
stay.
single judge
Stayed
also
what?
stayed the impugn order. My
No,
lord.
there is no
They
stay,
should not. They
lordship.
should kept the order in abeyance, my lord.
They
There is
said
an order.
that continue
Order
the
of 5th 6 2023.
investigation should be continued. This is division bench order, your lordship.
Investigation is over. For my learned friend understanding, investigation is over, my lord. Now it is about the filing of charge sheet. So the honorable division bench, my lord, has held in one of the matter not to arrest, and single bench has kept the matter in abeyance, my lord.
This is the order. Investigation is include filing of charge, also is a trial. The last, the next page, lordship.
1 second. Yes, so
This is the London single judge order, my lord, by which, and this order was passed prior to the division bench order.
in the same matter.
In the same matter, my lord, there are two different petitioners, my lord.
In the division bench,
Why did one go to division bench? Why did one go with the virus of the act?
Yes, lordship. Exactly.
Someone has challenged the virus of the act also, my lord.
Who has challenged the virus of the act?
In the division bench. In the division bench. And we are just challenging which. Can I submit, please?
Lordship.
Now he has no locus, my lord. He has filed a complaint, my lord. Now we are challenging the order of the local.
Don't have to be so aggrieved. Just submit.
No, my lord. It's not that, my lord.
Yes.
Only thing is this: he is not allowing me to submit, my lord. And
That's a style of advocacy.
No, my lord. That cannot be appreciated as an advocacy.
You have to make me party, lordship. That's what I am getting.
No, my lord. Here we are saying the section 21 is very pertinent.
So what happened to other case then? Where is this Boston marked? Is this case only?
Yes.
Or this one? Oh, sorry.
Yes, this is the matter.
I thought it's another case because this is just a ding dong. This is 164.
Since my learned friend is asking for some time for filing an affidavit, let him file, my lord. And the meantime, my lord, the interim order may continue till then, my lord.
What interim order?
There is an interim order to keep in abeyance, my lord. This is the order, my lord. In the missed case, my lord. There is an order.
Where's in this case?
This order.
It's a question of law.
It's a question of law.
It is a question of law. Because their limited stand before this honorable court
21.
is section 21.
Yes, my lord.
My response is 21 has no claim.
Okay,
But then
Mr. L. Jindal.
But then, as my friend was pointing out, the apparent slight mismatch between the DB's order, Honorable Division Bench's order, and this Honorable Court's order in the missed case, that may have to be resolved because Honorable DB has taken the stand that matter can proceed.
No, not matter.
But
Investigation.
Investigation can proceed, leading to charge sheet, etc. So the natural consequences of the investigation have to be carried out. The only restriction imposed by Honorable DB is that if there is a question of arrest,
They shall be arrested.
Do not arrest.
That is, they are challenging the virus of the act, my lord.
Learned-
Here we are not challenging the virus
single
of the act.
judge. Learned single judge has gone in another direction and stayed
Kept in
the
abeyance.
Kept in abeyance.
stayed the very order. So there is a, at least in my humble
But I think
reading,
the special judge is still,
Lordship.
he has fixed matter when.
On 23rd, today actually.
But then
And
he
then-
can't take up the matter because of the order.
Yes, my lord.
So, lordship, because
And
this
more-
order was not challenged because after the passing of this order,
No.
only they have filed
This order dated 5th of June, right? And the order taking cognizance 23rd of May, correct?
Yes. Yes. They have filed it after
That
that.
is on record, Mr. Day.
But my lord, we are not aware. Neither we have received any
Then,
notice. Neither we have received any notice.
Interim order will be a bit difficult to
Lordship.
continue with.
But till then, my lord, let the interim order be continued, my lord, because my learned friend is seeking for some time. Because I am hitting on section 21.
only because I'm seeking for time, Lordship should not be, that should not
Yes,
be the
Lordship.
ground.
Then my lord may kindly hear the matter. Hear the matter. Behind my back, can an investigation be carried out, my lord, without informing me? Without any complaint. I'm not even an accused in the complaint. My friend has not filed any case against of me. Now, section 20, if my lord may kindly see section 20, it is very clear, my lord. Section 20 and 22 will clarify everything, my lord.
Let them file an affidavit within 1 week. Mr. S. Jindal is entered parents on behalf of response 1, 2, and 3, and please be allowed 1 week's time to file affidavit of the incident application stopped. Praise allowed. Mr. Jindal has also submitted that some inconsistency has arisen with regard to the orders passed by the division bench in WPC number 172 of 2023 and in the present writ petition, whereby the coordinate bench at the time of motion has kept the investigation in abeyance. Like be that as it may, the matter will take consideration immediately after the affidavit has been filed. This after 1 week.
Only the interim order we can continue.
Till the next date, interim order. Dated?
5th month.
5-6 shall continue.
Hello, please.
It's a point of law, we'll finish it off next year.
Yes, well, it is a point of law only.
Notwithstanding other collateral proceedings.
Yeah.
Filed all the corrected matters.
In 21, I filed, and 22.
No, I don't want 21, 22. The prayer last time was that in 285, 508, 509, 520, 403, 511 has been filed.
403 they've already filed the affidavit.
Where?
403 they've already filed the affidavit. The matter is
403 already filed, 511 they already filed, 509 they filed, 520 they filed, 508 they filed, 285 they filed.
Your Lordship,
So 285
then
they filed.
In the 514.
1 second, wait.
Yes.
513 is not filed.
1 second, 1 second. See, is similar matters, correct?
Your Lordship, if I make a small submission, since all the matters are similar regarding pertaining to downgradation of pay from the 5th pay matrix to the 4th pay matrix.
No affidavit be necessary.
No affidavit should be necessary, Your Lordship.
Is that correct? We can go on the affidavit file already, Mr. Bharatiaji.
We have already filed, my lord, myself also I will file.
No, you file on only, see the other, they are 1, 2, 3, 4, 5, 6, 7, 8, 9 writ petitions when affidavits have been filed. And 1, 2, 3, 4, 5, 6 have been filed. The 15 cases altogether.
Yes.
9 cases affidavits have been filed. 5 affidavits have been filed.
One of the core issues is identical in all the matters.
Then in 4 cases I'll be filing during the course of the day. Everything is ready.
Which ones are those?
This is 514.
514.
523.
523.
507.
507.
509.
509 is already filed.
No. It's not filed. Actually, it is not filed yet.
Then why was the wrong submission made last time?
Did somebody make a wrong submission? But on record, I'll be filing during the course of the day. I have prepared one.
Mr. H. Abraham submits that affidavits in WPC of 507, 514, 523, and 509 will be filed in the course of the day. Counsel and petitioners, however, submit that as the issue involved is similar in all respects across all the writ petitions, the matter can be posted for hearing on the affidavits already filed. Correct?
In the meantime, I'm allowed to file.
Accordingly, the matter for hearing, any affidavits that be, parties are at liberty to file affidavits and rejoinders in the meanwhile, list after 4 weeks. 4 weeks time, you have enough time, you file the joinder if necessary.
403 is listed as item number 35 in the hearing list.
Today. Yes, we list together with item 35 to same matters.
Same matter, connected matter, yes.
Go make list 35, I'll list up. Go along the same order. Just check it up, registry to verify. Correct order. Yes.
Hearing item 41.
Yes.
Please, Your Lordship, on the last date, Your Lordship had asked the counsel for the respondent to bring in The letter dated 26, bringing the petitioner into casual worker.
Yes.
In fact, there are 3 communications.
What was the issue? Mr. Kibi Barsaji obtained specific instructions on the letter date 2610. What is the letter date 2610/22?
Your Lordship, here the contention of the petitioner is that she has been working as a casual worker since the year 1991, whereas according to the state respondent, she is only a part-time worker, and that white letter 2610/2022, they have intimated that in the year 2021, she was brought into as casual worker, only in the year 2021. So, Your Lordship, since we don't have that letter, Your Lordship had asked him to produce the letter today.
What communication do you have?
So these are the letters which clarify, my lord, when the petition was brought under the scheme of. Okay, I'll give you one. So this is letter dated 1/12/21, my lord.
But they filed this petition since
Then
2019.
subsequently, my lord, 15/12/2001 is the 2021. With reference to the subject cited above, I'm to say that the revision of wages in respect of the 2 part-time cleaner is approved with effect from November 21.
Where reading?
My lord, the first letter is 1/12/2021. This is where a clarification is sought, my lord. And subsequently, the second letter, the following letter, my lord, which is on the next page.
You've shown her those letters.
We'll give her a copy of this.
Your Lordship, if I may be allowed to clarify, Lordship. Your Lordship, if I may take Your Lordship to the additional affidavit filed by the respondents, Your Lordship, page 6.
Where? What?
Additional affidavit filed by the respondents, page 6, annexure 2.
Which additional affidavit? My lord, this was filed on 10/2/2023. This year, my lord, in the month of February.
Page?
6.
Page 6.
Yes, Your Lordship.
Yes.
Your Lordship, point number 5.
Yes.
It may be stated that she has already been brought to casual worker on November 2021 and her salary has been paid with the minimum wages of the Labour Department. It was regards to this, Your Lordship, that Your Lordship had asked the respondents to provide.
Yeah, but the thing is that
her
now,
to casual.
by this document, it shows that she was a part-time worker only and was brought to casual worker only in November 2021.
Yes.
So to be eligible for RCW, that means she'll be eligible in 2031.
Your Lordship, materials on record, Your Lordship, as per the petition which we have annexed, Your Lordship, shows that she was appointed as casual worker, Your Lordship.
So on November 2021.
No, Your Lordship. If I may take Your Lordship to the reply filed by the petitioner to the affidavit, additional affidavit, Your Lordship.
Where's the reply? What have we said?
Reply is 24th February 2023.
Yes, para.
Your Lordship, page 6, Your Lordship. Srimati D.K. Chetri is appointed as casual cleaner on casual basis, Then, Your Lordship, also the respondent have admitted in their affidavit reply, Your Lordship, in paragraph 7, page 3.
In the additional affidavit?
No,
No,
just
Lord,
the
that was
affidavit reply.
the affidavit which was filed, my lord. Affidavit in opposition. My lord, we have clearly stated there.
1 second. Where?
Page 3, Your Lordship, paragraph 7. The last 4-5 lines, Your Lordship, whereby it was clarified that the petitioner was appointed as a casual cleaner. Your Lordship, even the working hours, Your Lordship, It's from 8 to 10. In their additional affidavit, Your Lordship, they have stated it's only from 8.
No, but your point is a part-time cleaner. That means you're not you're casual only. It's not you're not work charged or.
Yes, Your Lordship.
That is what we
cleaner.
stated, my lord, that she is not a work charge staff. This is, para 7 is very clear. This is what we state, my lord. Whereby it was clarified that the petitioner was appointed as a casual cleaner, drawing a salary from, my lord, this salary account itself, my lord, from where the salary is being disbursed. That itself is, we refer to the same page, my lord, page 3, para 7 of the affidavit, which is relied by my friend, my lord.
But the thing is that, see, as per the scheme of that regular casual worker scheme, casual worker means a person by nomenclature is employed doing work daily wage basis. And if she's doing work on daily wage basis, that means how can you deny her? You consider?
Your Lordship, if I may also point out, Your Lordship, one Shrimati Mercy Donman, Your Lordship, who is junior to her, she has been conferred RCW status and she's also got a sanctioned post, Your Lordship. And Your Lordship, if I may, Your Lordship.
Mr. Parasari?
My lord, exactly on this question, my lord, the department has replied on this letter, my lord, 26th October 2022, which was brought on record before this honorable court, where the department has stated, my lord, why she cannot be considered under the RCW, my lord. So, para 5.
Where you said that?
My lord, this is additional affidavit, which my friend had relied, my lord, in the earlier occasion.
Your Lordship, if Your Lordship may just say this, Your Lordship.
1 second. Where we said what?
My lord, this is that letter, annexure 6 of that additional affidavit, which was filed on 10th of February, my lord.
Annexure 6?
No, my lord, my apologies. Page 6, my lord. If I'm allowed to read, my lord, because several points have been stated there.
Maybe. Only one difficulty is there, MS Savian, in your case. Because you appeared under minimum wages only.
Your Lordship, that 2021, Your Lordship, wherein she was paid minimum wages, latest minimum wages, Your Lordship, that was only after filing of this writ petition. Prior to that, she was only paid 5,000, Your Lordship.
Consolidated pay every month.
Yes, Your Lordship.
We're not going anywhere. I mean, it's not the case, not going anywhere. Like, it's just on this kind of. Because the only thing that initial appointment was casual worker, correct?
Yes, Your Lordship.
And what does RCW scheme say?
Well, the RCW.
With regard to status of casual worker.
Well, they have to be working for at least minimum period
Correct,
of 10
years. Now she's upon 93 as casual.
Here
Now your stand now is that she's working as a part-time cleaner only. Her working hours from 8 to 10 only. She's not come the definition of casual worker. She comes the definition of a part-time cleaner. Correct. That's it.
And that is what the letter also says.
I'm not doing that. That is the stand of the respondents.
Because she is, according to the department, my lord, she is neither a work charge nor a dock employee.
No, a doc, even Mastrol is there also. They are put on the RCW scheme. They also paid daily wages.
Your Lordship, if I may just. Give your lordship this one, your lordship.
What is that?
This one is the list of cleaners in the office, your lordship. Your lordship, in the year 2014, one Srimati Mary Kharshandi was appointed as regular cleaner in the office, when they have instead given verbal assurances to the petitioner that she will be regularized.
No, he also shown as DG Chetri part-time cleaner.
No, that is just shown, your lordship, but then according to the materials here, it shows that she's a casual cleaner. But
Where?
your lordship, by this,
It says regular cleaner appointed 3/2/2014.
your lordship, that is just to show that one was appointed as regular cleaner in the year 2014.
Well, that's all right. That's different. That's by selection.
there are sanctioned
You have not.
posts
You have not. You
available
have
in
not
the
come by.
office.
You can't claim regularization as sanction post. This original noting you got, huh? This one.
Yes, your lordship, by way of RTI.
You're still in service now, correct?
Yes, your lordship.
I think tough case for your client, and not for you. Why is my affidavit file? Take down. You want any more instructions or dispose it off on these other letters?
Your lordship can dispose it off, your lordship.
Yes.
Your lordship, my prayer is that at least RCW status may be conferred, your lordship. She's been working for the past 30 years.
So, the writ petitioner is before this court. For regularization, absorption of a service as cleaner in the office of the respondent number. Where are you serving? Number 4. Which
Number
one?
5, your lordship.
Oh, number 5 stuff.
Number 4, your lordship, sorry.
Number 4 stuff. Next paragraph. The case of the petitioner is that while order dated, where is the appointment? You please assist the court.
Appointment letter?
Yes, the first
On
appointment.
page 6, your lordship, of the reply affidavit.
No, first appointment. You don't have it in writ petition.
No, your lordship, in the petition, because we could not have it at the time of
Yes, Lord. Not done, nothing.
It is in page 10 of the writ petition.
Page 10.
No, that is 1999. That is 1999, your lordship.
Please be sure.
Page 6,
Page?
your lordship, page 6 of the reply affidavit by the petitioner.
Page 6 is not.
Reply affidavit dated 24th February 2023.
For the last affidavit.
Yes, your lordship.
Only reply affidavit, okay.
Yes, your lordship.
That's why it's better pass an open court, yes. So, page 6 is right, order. Which 93 is 19 July?
Yes, your lordship.
Right, order.
19 July.
When?
19 July 93.
Right, office order dated 19 July 1993. She was appointed as cleaner on casual basis on a monthly pay of 1,000 per month, with effect from 1st April 1993. The appointment, as shown in the order, was purely temporary and was purely temporary stop. Thereafter, after serving for a period of, when did you first make a prayer for regularization?
2019, on
Where is that?
retirement of one Srimati Kharmujai.
Where is that? Any other petition?
Your Lordship, page 17.
Thereafter, after serving for a period of whatever years, the writ petition on 18/2019 preferred a representation before the respondent number 5, praying for realization of service. Inasmuch as she has been serving punishment in the said post. The further case of petitioner is that she has become eligible for absorption as per the scheme, as per the Meghalaya Regular Casual Workers Scheme 1996. Stop. Next paragraph. MSCB Sovereign Letter Counsel for the petitioner has drawn the attention of this court to the first appointment order. And also, what did you show just now?
Your Lordship, the list of those.
Not the list, the other document that appointed as casual. Where is that?
Cleaner and her working hours also, Your Lordship.
Where is that?
To 10. That is page 10A of the main petition.
Of the main petition?
Yes, Your Lordship. 8 to 2 p.m.
10A.
Point number 2, Your Lordship, copy 2. She is also to note that the working hours from 8 a.m. to 2 p.m. daily.
10A.
10A, Your Lordship. Copy 2, number 2,
yes.
DK Chetri.
No. And also to a letter dated, an order dated 4/11/1999, whereby the petitioner has been directed to attend duties, her working hours from 8 a.m. to 2 p.m. daily. Stop.
This was, my lord, because she was serving.
Doesn't matter.
As a result
she further submits that as she was employed as a casual worker and serving long hours in the said post, the petitioner is therefore entitled for consideration, for absorption, or for conferment of the status of a regular casual worker. Stop. Next, Mr. Kibi Varasaji, in his reply, letter GA, submits that the petitioner is not entitled to the benefit of conferment of RCW status inasmuch as her initial appointment was not as a casual worker, though the order reflects so, but was purely as a part-time cleaner with limited working hours from 8 a.m. to 10 a.m. Stop. He further submits that the status being such, the writ petitioner would not come within the definition of a casual worker, and therefore and has been put as a casual worker since when only? Has been put as a casual worker since
November 20.
November
2021. This letter is at page 6, my lord.
Of the affidavit?
Page 6 of the additional affidavit.
Hold on, Darian. Page 6.
Page 6 of the additional affidavit dated 10/2/2023.
Page 6. Yes, does not come together, and has been brought as a casual worker as cleaner only on November 2021, and the salary has been paid with the latest minimum wages for unskilled laborers. He further submits that to be eligible to be considered for conferment of RCW status, an employee should have served for not less than 10 years of continuous service in the same post. So, hence, he submits the writ petitioner will be entitled for conferment of status only in the year 2031. Next paragraph. Anything else to say?
But here on certain occasions, my friend is relying on that 8 to 2 p.m. my lord. Now that is because he was officiating on someone else's leave vacancy, my lord.
Okay. Anything else to say?
My lord, this is the major stand.
That's the major
and
stand.
On other occasions, whenever she has performed her duties, otherwise also these are all on, my lord, vacancies created.
Heard the counsel with the parties. Their perusal of the materials as placed before this court reflect that the petitioner was appointed as far back as in, when was that?
1993.
On 19
1993.
July 1993, and has been serving continuously in the same post, whether as part-time or for longer hours, which cannot be discerned by this court at this juncture. Stop. Though arguments have been put forward, the arguments have been made by the respondents that the writ petitioner, though appointed as a casual cleaner, will not come within the zone of consideration for RCW, as he was not an ad hoc appointee or a work charge staff. So, this court, on further examination of the career of examination of the documents as placed, what is the annexing affidavit, work child staff, and the scheme and all?
RCW status?
Not RCW status. In this first affidavit of
the first affidavit we have stated, my lord,
is not very clear.
My lord, we have referred to the circular, my lord. What is work charge establishment, my lord?
Yeah, but it doesn't come within the meaning of work child establishment at all.
Of course.
Or a work child staff. Finds that there is no nexus with the averments in the affidavit with regard to work child status vis-a-vis the service conditions of the writ petitioner. Stop. An additional affidavit had also been filed by the state respondents, whereby the earlier instructions aforementioned have been brought on record. Today, further documents have been produced by the state respondents with regard to the factum of the revision of wages of the writ petitioner as part-time cleaner. Stamp. This same are also noted. Next paragraph. Looking into the totality of the circumstances, the undisputed fact is that the writ petitioner, by the initial appointment order, was appointed as a cleaner on casual basis, though on a consolidated monthly pay of 1,000, which was later enhanced to 5,000, and thereafter was put under the minimum wages. Was put on minimum wages as applicable. Stamp. Though it cannot be distinctly or clearly seen that it can distinctly ascertain as to the status of service, as the status of the petitioner in service, as to whether she was employed strictly as part-time or whether she discharged her duty as a casual worker having longer hours. So this court is of the considered view that looking to length of service and the kind of duties discharged by the writ petitioner is by taking into account the weather scheme. Regular casual worker scheme.
Is it enclosed?
Wherein?
No, that scheme of course is not enclosed. Is it enclosed?
Wherein at explanation 2, casual worker has been wherein at wherein it has been written as follows. Stop. Inter alia, that it shall apply to casual workers employed in the departments and offices of government of Meghalaya, and wherein at the explanation 2 small a, a casual worker has been defined as follows. Comma. So I have to take down the 2 here. It would be in the fitness of things if the respondents are directed to consider these case of the petitioner for conferment of RCW status. Stop. Next paragraph. This order is made in view of the fact that, and I thought I'll get it on. Yes. The said exercise, these respondents shall complete the said exercise for consideration of the petition service for conferment of RCW procedures. Within how much time? I'll embellish the order within 3 months. Yes. Because you see, it's not clear. She's worked, if she's officiating, she's worked for longer hours. And it's just, it's on equity.
There was
else.
one actually Supreme Court judgment also. So that might be of.
What does it say? Against her?
This is against the part-time workers.
You haven't shown it, it's too late. Yes. Next.
44?
Yes.
Please, Your Lordship. Your Lordship, on the last occasion has given me time to seek instruction on the with regards to the prayer portion sought in the petition. Your Lordship, before coming to conclusion, I would like to draw your kind attention to the first list of beneficiaries, Your Lordship, and the inspection report, Your Lordship. It is clearly mentioned that the
Forgotten everything.
Yes,
I don't
this
remember
is
this case. What is this matter
this is
about?
regarding misappropriation of fund, Your Lordship,
By
and
whom?
implementation of the central government scheme by the private respondent, Your Lordship, Chairman and Secretary.
What scheme?
This is the Swachh Bharat mission, Your Lordship, for construction of latrines in the village.
What instructions? What it's like a PIL.
Your Lordship, with regards to the inspection report, it has been clearly mentioned that the work has already been completed, Your Lordship, and then the sanction amount of 12,000 for each beneficiaries from the first list has already been fully disbursed, Your Lordship. Yet the private respondent, I don't know under what authority they have made another list, second list, Your Lordship. And then they have manipulated and misappropriated the fund, Your Lordship, and then they have only distributed only marginal amount to the beneficiaries.
On what basis? Do you have materials to show that they received only a part of the money?
Your Lordship, they have. We don't have that, Your Lordship.
Then,
but then, as per
that is why I remember now you took time to seek instructions to validate your submissions. Correct?
Yes, Your Lordship. So my humble submission is, Your Lordship, that they might the court may direct the respondent, Your
print the
Lordship.
records.
No, Your Lordship, for them to pay the full amount, Your Lordship. to
How
the
did it? You
beneficiaries.
cannot validate the very thing that you say they paid short payment.
Yes, Your Lordship.
Then
They have just
how can we direct them
distributed
to pay?
only the marginals, Your Lordship.
I think you file a criminal case then.
Your Lordship, on the earlier occasion, we have already filed in the lower
Criminal case.
No, Your Lordship, is the
Misappropriation you file? FIR that this so and so person has.
FIR already filed, Your Lordship.
What happened to FIR?
But then it was left unattended, Your Lordship,
Where's the
because we
FIR?
have approached.
Your committee is called Kenhun Wajing Shisha.
Your Lordship.
Yes.
Your Lordship, FIR was filed in page 65, Your Lordship, of the writ petition.
What happened to this? Was the case registered?
Yes, Your Lordship.
What happened
It
to
was
the case?
registered. But then the same has been withdrawn, Your Lordship.
Withdrawn, then that means your case is over.
Withdraw, Your Lordship, so that to enable the complainant to approach the higher authority, Your Lordship. That's
See,
why
the
we
thing
have
is
come.
that if court's not to say, but anyway.
Your Lordship, my humble prayer is this honorable court may direct the respondent to pay the full amount to the beneficiaries as they are entitled, Your Lordship, because the amount that they have disbursed was for the first beneficiaries.
How? See, if you don't have any concrete materials to go on that there has been a case of misappropriation, where have you said that? Where's the statement recorded, or where is that? You're asking your prayer, see.
Yes, Your Lordship. The first prayer, Your Lordship. That this honorable court may be pleased to issue notice upon the issue an appropriate writ or orders or direction as why the imputed exclusion of the name of the writ petitioner number 5 and 6 from the beneficiary list, as well as inordinate delay release of all amount to the writ petitioners 1, 2, 3, 4, 6, 7 and 8 should be held unconstitutional and illegal, Your Lordship.
You renew your FIR then. I'm afraid on this prayer. Yes, Mr. Kharmi.
Lordship, the complaint case filed before the magistrate.
Withdrawn.
Not the magistrate has acquitted them. Has acquitted the
There's a complaint case
respondents.
also.
Lordship?
There's another FIR. There's another case.
Complaint case before the magistrate.
Acquitted or discharged or what?
Acquitted.
Your
It's
Lordship,
acquitted.
it
The
has
order
been
is at page
acquitted based
74.
on our withdrawal, Your Lordship.
The order is at page 74.
Oh, that is what?
complaint regarding misappropriation. Their allegation is misappropriation. Page 74, Lordship.
Your Lordship, they have
Last
been
paragraph. Last paragraph.
they have been acquitted based on our withdrawal, so that enable us to approach to the higher authority, Your Lordship.
I'm afraid, Ms. Garcia, you don't have. Show where from your annexure show the materials
Yes,
that have been short paid.
Yes, Your Lordship.
Where? Also inquiry against the BDO. RTI also said that everything is done right.
Yes, Your Lordship.
Then
Yet they have made another list, Your Lordship. We are agreed with that one, with the second list of the beneficiaries.
Which page second list?
It's page number 36, Your Lordship.
What amendment have you made in the petition?
And the FIR also, Lordship, the investigation has submitted a final form due to lack of evidence.
No, I mean, where? Which? The same FIR?
FIR they filed.
FIR they filed, you withdrew the case.
Yeah, they have withdrawn.
But they can withdraw before, this complete. The magistrate has the power to withdraw.
Yes.
Your Lordship, it's point number 11 of the writ petition which we have mentioned regarding the second list.
11.
Yes, Your Lordship. Page 8. Page 8, Your Lordship.
But does it say nothing?
Your Lordship, I may be allowed to read.
Yes, that has by the way made another list of beneficiaries beside the first. So, is there any prohibition that they cannot make a second list?
Your Lordship, this is without approval, Your Lordship, because we have made the first list with approval, Your Lordship.
I'm sorry, I think we'll have to reject your petition. Take down this. Yes, Mr. Kharmi, anything to say?
Lordship, in the affidavit also there is a statement.
Yes.
The disbursement details.
We are not going to
private respondent, Lordship, disbursement details. Every expenditure has been.
Where is that? Where is that disbursement details? Page of your affidavit?
Affidavit filed by the private respondents. Page.
Who's been private respondents?
Page 32.
The when is standing up?
Page 32, Lord.
Where?
Page 32. This is the disbursement details. Page translated copy is at page 38. Lordship. Everything is shown here, Lordship. The expenditure and the everything.
Take down this writ petition. The writ petitioners, by way of the writ petition, have complained about the manner in which the funds allocated for Swachh
Bharat mission.
Implementation of the scheme under Swachh Bharat mission.
Of the
Swachh
Bharat implementation of the scheme for construction of latrines.
And the Swachh Bharat mission for construction of latrines.
For the
household latrines.
Probably I'm just complaining about the have been misutilized. Has complained about the alleged misutilization of funds in the implementation of the scheme for construction of latrines under the Swachh Bharat mission. The writ petitioners have prayed that an inquiry be conducted against the concerned respondent BDO, as also the private respondents number 6 and 7 for the said alleged misappropriation, besides from a prayer against the exclusion of names
Yes, Your Honor.
of the writ petitioner number 5 and 6 from the beneficiary list. Stop. Next paragraph. MSA Kharshi, the counsel for the petitioner, submits that in the implementation of the scheme, the sanctioned amount for each beneficiary was not released, but in fact only a portion of the same was given to the beneficiaries.
It was already disbursed, Your Lordship, but
Was
they have
disbursed
not,
to the beneficiaries.
but they have not.
She further
distributed.
submits that after a first list of beneficiaries had been published, the respondents, without any approval or authority, had released a second list. Stop. A further stop. It has also been contended that in the implementation of the scheme, no proper inspection was carried out, and that an inquiry
Did
was done.
not follow the guideline, Your Lordship,
Yes,
of
no inquiry,
house-to-house
no
identification.
proper, was carried out, and neither were the guidelines. What guidelines are those?
Guidelines.
Neither the prescribed guideline for construction of such latrines followed, which has resulted in loss of public money. Stop.
The instruction in this work orders, Lordship, is before releasing the amount, the village must constitute a local committee. That it has been done, Lordship, and the
No, that
list of
we'll come to your
beneficiaries they have
submission
prepared.
later on. Let us just finish with her submissions. Stop. What else you have to say? What else you have to say? That's it. She therefore prays that appropriate orders be passed, directing for a proper impartial inquiry to be gone into, so as to unearth the misappropriation and defalcation of funds by the respondent BDO, as also the private respondents number 6 and 7.
Your Lordship, my prayer is to release the full payment to the respondent, to the beneficiaries.
And that the full and that the amount which stands unreleased to the beneficiaries be released forthwith. Next paragraph. Mr. H. Karmi, additional senior again.
Additional senior.
Appearing for the respondents number.
Respondent number 1 to 3, 1 to 4, Lordship. 1 to 4.
1 to 4.
1 to 4.
Submits that there has been no illegality in the implementation of the said scheme, and that regular inspections were carried out by the respondents for ensuring timely completion of the works. RTI queries to this effect had also been replied, and that the identification and selection of the beneficiaries which is the sole responsibility of the village authority, had also been undertaken. Undertaken by the said village authorities. Is that what you said? Correct?
Yes.
Though what other submission do you have? Only the FIR is filed, not the other submission.
And there is no misappropriation also.
Okay.
And from the video office also, all the amount have been released.
Further, council submits that the amounts as due have been fully released to the beneficiaries, and that an FIR which had been filed by the petitioners and which was taken cognizance by the magistrate was also subsequently withdrawn, and all acquitted and the accused therein were all acquitted. He finally submits that the matter also in the realm of disputed facts as to whether the names of the beneficiaries have been repeated or repeated, right?
Repeated, but we have corrected that name.
They corrected also.
Corrected. It's enclosed in the corrected list.
Yes, the second list.
The second list.
Pom shukato in the realm of something. So I'm sure I'll send it to Langkomna. Cognizance.
Cognizance by the magistrate was also subsequently withdrawn, and the accused therein.
All right. After that, that's the last one. Fine submits. The Land Council also submits that the errors that are corrected in the list of beneficiaries were also corrected
and submitted to BDO,
and duly submitted to the office for records by letter dated 23rd September 2018, and the same has been annexed at Annexure 1 to the affidavit filed by the state respondents. He finally submits that there is no irregularity has been committed, and the scheme has been implemented in accordance with the guidelines and directions. And beneficiaries, what is this page 42 of your affidavit, Mr. Private Respondent? Or page 27, sorry.
Page 27. Page 27, Lordship. Oh, this is the meeting, Lordship. Meeting held in the village. And the beneficiaries also have attended the meeting. And in that meeting, Lordship, the audit report, it was placed in the meeting and read out. And they have accepted, the beneficiaries, they have accepted the audit report also. And now they are raising and coming to report again.
That no error has been committed in the implementation of the scheme. Yes, stop. Mr. Next, Ms. H. Abraham, appearing for the private respondents, has placed reliance on his affidavit. Since he made the submission and submits that that all the beneficiaries in the list as provided have received the benefits on the scheme, and that the committee, the duly constituted committee of the village, has also corrected the list and submitted the same to the office of the BDO, and that the name of the petitioner, number 8, at serial number 20, which was repeated at serial number 123, has been corrected. Is that correct?
Yes.
Stop. Yeah, stop. In the execution of the project, the council submits that public meetings were conducted by the committee wherein the beneficiaries have been explained with scheme, and also the audit report was read out in detail in the said public meetings, which was accepted by the beneficiaries. So, he finally submits that the entire scheme of sanitation was implemented in a transparent manner, and any eligible beneficiary was not denied the benefit to avail of the scheme. So, he therefore submits that there being no merit in the petition, the same be not entertained. Stop. Paragraph. I've heard the counsel of the parties. Stop. In perusal of the writ petition along with the affidavits as placed shows that the only point in issue is with regard to the grievance of the writ petitioners in the manner of implementation of the scheme, and wherein allegations have been made that the beneficiaries were not paid their full amount. Now, on the earlier occasion of hearing, learned counsel for the petitioner, M.S. Ekharshiyeng, had sought time to obtain instructions to validate the government's main writ petition to the factum of misappropriation and deprivation of certain beneficiaries' stock. But you cannot bring anything
Your
else.
Lordship, just to bring to your kind attention, page number 13, Your Lordship, we have made an averment, Your Lordship, regarding
Of your
petition, Your
petition?
Lordship. Yes, Your Lordship. We
Page
have
number
made
13.
13, Your Lordship. Point
Yes.
number 28.
Okay. Those ones, huh? 28.
Yes, Your Lordship. We have made an averment, Your Lordship.
Though an averment has been made at para 28 of the writ petition that as per RTI, no, the averment that at para 28 of the writ petition, para 28 of the writ petition that known that as per that the implementing agency, respondent 6 and 7, had disputed between rupees 3,000 to rupees 9,000 to some of the beneficiaries of the list of 145 and list of 174. Stop. No materials have been placed to substantiate this contention. Stop. Next paragraph. The point in issue, as noted earlier, stands clearly in the realm of disputed facts. Stop. Further, as pointed out by the learned senior AG, the FIR on which Ben Salah PS case number 33 bracket 10 2018 was registered was also withdrawn by the petitioners, and the accused therein acquitted. Stop. Next para, faced with this situation and in view of the disputed facts that are involved in the instant matter, wherein a court under writ jurisdiction is not in a position to discern and ascertain the competing rights and claims of the parties, the instant petition is not entertained and is accordingly dismissed. Parties to bear the one cause.
Highly obliged.
You should have stuck with the criminal case, then statements have been recorded, yes.
45.
Yes.
Your Lordship, I have prepared the matter, but I require some guidance, Your Lordship, from Mr. Paul. So I'm praying for some time.
Guidance? What guidance?
Lordship, this matter it's not. It's a little bit complicated for me, Your Lordship. Even though only the written statement was close, I require some guidance with regard to research and all that.
Why you're more than competent to do the case?
Lordship, I got the judgment of Salem Advocate Bar Association.
Yes.
And I require some more research.
Lordship, it is a bank money. 30 crores 79 lakhs is stuck up. And this tribunal has passed the judgment. Recovery order already. Now, if you are they want to appeal, there is a forum. Appellate board is there. They should go. They should follow this sections 20 of this DRT Act.
Okay, just in terms of justice, we'll give her one more opportunity.
Lordship, next week.
Lordship.
Next week on Tuesday.
Lordship.
Lordship, this matter. MS, we have Kharwanlang said that some more preparation is required and pray some accommodation. Accordingly, this is matter after 1 week.
Highly obliged.
You prepare it.
Your Lordship.
Because the point, you're right, is small, but it's an interesting point.
Lordship.
Highly obliged.